Hello, this is Jennifer Utter, Professor for Human Resource Law, LA 6570. This is information for the LP3 Seminar. In LP3, you're going to really explore what it legally takes to right the wrong that discrimination has caused. And so you're going to be learning about the legal rules for affirmative action. And the biggest concept for you to remember, affirmative action is a form of legal discrimination, right? Because you're now focusing on building back up your employee pool or your employees themselves with a more even or representative mixture of the relative talent pool. And so for a time, there have been policies and actions that the courts have allowed to enable an employer to, for a limited time and sufficient time to right the wrong or correct the discriminatory action that has occurred in the past. There is a window of time where employers can put forth a plan and implement that plan so that they can have that non-discriminatory effect in their, for instance, hiring policies. So this is a very interesting concept in the law, and many have talked about the fact that perhaps this has resulted in reverse discrimination. And that is so much so trying to affect the affirmative action and really involve all these other possible categories of prior discrimination that now the other talent pool in that employee field is not able to get a job there or is not able to get into college there. And the idea of quotas has come up, and that is a very sensitive subject, and but something to really think about. Is there occurring in the employment field and within our business industry reverse discrimination? And so always when you're trying to look at affirmative action and the limited purposes that it has and the limited time that it's applicable to just get that corporation or get that industry back up to a non-discriminatory level in terms of their employment. But you don't want it to go too far. And there are some cases, and they're very interesting to read if you are focusing on this topic and as you're learning about this topic. So affirmative action is okay within certain parameters. However, quotas are not permissible, and reverse discrimination could possibly occur. And those lawsuits have happened. So ultimately, what it comes down to, who is responsible for discrimination and who is responsible for correcting it. And when an employee is suing a corporation, they name everybody. They're going to name, because of these principles of employer responsibility, a manager is an agent or could be an agent considered of the business, and especially within the scope of the duties of the manager. So sure, the individual manager is going to get sued, but they're also going to name the company. And the reason, of course, that they name the company, that's the person or the entity that's going to pay them. The individual manager makes whatever they make, but you're not going to have a really successful lawsuit unless you go after the deep pocket. And the deep pocket, in most cases, is the employer. So take a look as you're reading in the materials. Really look at these particular areas of employer responsibility. mean, employers have a responsibility to train not only their managers, but their employees. Many of you have talked about in the discussions, and you're doing a good job. Carry on. Many of you have talked about that the fact that you're just always seem to be training on something. And the reason is because employers want to be able to say, this was mandatory training and I can't help their personal actions. Basically, the employer has done all they can to prevent and head off any type of discrimination or harassment that might occur in the workplace. Knowledge is power, and documentation of your efforts to impart knowledge to your employees, especially if you're working in the HR department, you're going to want to cover that. You're going to want to protect your employer, and the employer is protected to some extent if they offer training and they also act on complaints that they have. That's why it's important to have an HR department in place so that complaints can be acted upon, and also that they follow the law. So they know the law and they follow the law. Putting in place those policies and procedures that follow the law and that get updated as the law changes, that is the best protection that an employer can have. And in many ways, not only is it a personal benefit to the corporation and the employees, but it's also a way of insurance, not or operating similar to that theory of insurance. If you're going to, be in this business and enter into this field and hire these employees, then follow the laws, act on complaints, train your people, have some policies and procedures in place so that you can say, we followed our policies and procedures. These policies and procedures comply with the law, and we can't help it if somebody is a person who is conducting harassment or discrimination. It's not our fault. And so very often when you're looking at, employer liability, look at the position of the harassers set up within the company. What type of action or what type of authority do they have? Is it the CEO of the company that is just the bottom line person, or is it a production line harassing fellow employees that are at the same level, or maybe a supervisor of the production line? And take note of these legal principles. Vicarious liability for higher level officials, for managers and supervisors, if there is a tangible employment action. So not only does the harassment or the discrimination have to occur, but there also has to be some kind of tangible employment action. Once again, go back to the elements of the claim, and if there's no harm, then potentially there is no action. Look at the theories and do your reading, and just note when there's a discussion about a hostile environment. This is vicarious liability towards supervisors and managers, and an affirmative defense. Go back to those policies and procedures and the training that a company has, is that the company has taken reasonable care to promptly prevent and correct. So that hostile environment, so you might have a manager, and then you might have a line supervisor, and then maybe it's that supervisor that's under the manager that is doing the harassment or discrimination action to employees that are once again under them. Well, that vicarious liability goes up the chain. And so that's why it is so important, even if you are a small business that's under 100 employees, and many of us work for those small businesses, to really be able to say, we did all we could. And so this vicarious liability, it's not that we didn't try to fix it. And, we can't help individual actions and free will down among the ranks. So if the harassment is occurring among fellow employees at the same level, it might be considered negligence if the employer knew or should have known of the harassing behavior just among employees of the same rank and file, and they took no action. So if they knew or should have known, and there's a real reasonable standard, certainly a complaint, they know or they should have known if there was a complaint, or perhaps there were requests for reassignment, and or just absolute outright witnessing of this harassment. So it's important that everybody along the chain is familiar with the rules and familiar with how to address what's going on, and really timeliness is the key. You don't let stuff like this fester. Issues like this. So let's look at the HR department, and some of you work in HR right now. Often it's the nuts and bolts of the compliance with the laws, the federal and state laws, with union contracts, and it is that job of the HR department to just do the work and know what the work is and come from a place of knowledge and experience that you can really address these issues and protect yourself against legal action. So especially if you're looking at a director or manager position, there are some considerations I would really like to focus on. So many people, especially students, and I know that all of you are experienced students. I mean, you're out in the world and you're working and you've had jobs, and so you really have a different perspective than somebody coming into this program right out of high school without that real world experience. And believe me, especially in view of the discussions, I can see you have that real world experience. What I would like you to do now is set aside that never had a job, just graduated from high school or just graduated from college, don't really know what's going on, and put on the hat of the director or the manager of human resources. For that job, you must have a big picture of the duties of HR, of how to protect the company on a global level. And this person, this director or this manager, this is going to be you guys, are going to go to the upper levels of management. You likely will be reporting to the CEO or and I just have in my mind the organization of National American University. I mean, there's a campus director. Yet there's also a system director, and there are levels within that system. But you're going to be proposing the policies to upper levels of management. Let's have a policy of inclusion. Whether you phrase it in the negative, let's not have discrimination, or let's have a policy of inclusion. Call it whatever you wish. But knowledge of the laws and the responsibilities of the employer is so important for you. Think like the director. Think like the manager. Don't think like the high school graduate. You are there to protect the company. You are there, and in the course of protecting the company, you also protect the employees as well. So you're going to be proposing policies to upper levels of management. You're going to be proposing procedures to ensure compliance with those policies. And those are all need to be in compliance with the law. This is a really important position, and I really applaud those of you who are interested in focusing on human resources as a career. It is so very necessary, and especially as your company grows. But even for those companies, 100 employees or less, considered small businesses in the eyes of the government. Everybody needs this. Everybody needs to know. So this is an important study for you to be doing in this class. These policies and procedures need to be effective. They need to be efficient. They need to be easy to apply. Somehow within your company, to develop this culture of compliance and training new employees. And finally, this redundancy in review of application. and the system checks, you want to make sure that all these effective, efficient policies that have been developed, this culture of compliance that's been developed, that somehow there's a way that internally HR can get feedback on this. So maybe you have some system checks, maybe you have some checklists that new hires must, or interviewers for the company for new hires must complete. You've got some action items, and there's a way for the HR department to check to make sure that this is working. And if it's not working, then there needs to be some proposals for review. A few words about the Family Medical Leave Act. There are so many acronyms in the HR field. This one is the FMLA, and there are posters actually that, for instance, employers in South Dakota can order, and I think employers all over can order from the federal government, that talk about the advisement to employees, and we've probably seen those. I know I have in various positions, usually often posted in break rooms or posted in supervisors' offices, where there might be those conversations about, my elderly mother is really having difficulties, and I need to take some time off. She needs to come live with me for a time for health reasons, for instance. And so often in those places, there are these advisement posters, and it is the employer's responsibility for advising employees. So often you will have a handbook that has written information about how to access the Family Medical Leave Act. You have these posters that are up not only in break rooms and lunch areas, but in the offices of the supervisor or the person in your office that you'd be going to talk over a situation where you might need to take some of this medical leave. And but the employees have some responsibility as well. And the employees have the responsibility for notification to the employer that they are either considering or actually going to take the family medical leave. Employers develop their procedures. You make sure that there's documentation that the employee has been notified of their advisement of all of their possible rights and possible options under the Family Medical Leave Act, and that it's the employee's responsibility for notification of the employer in a timely way. There's some interesting cases in your book to look at and to really think about. So those are a few comments about LP3, and we've heard now and learned now about all the bad stuff that can happen, and LP3 is really all about, well, let's find out more about how we can protect ourselves as employers so that we also not only benefit the employees individually, but benefit our company as well by avoiding legal responsibility and legal action. So this is a fun one. The LP3 Seminar Assessment. Once again, you can submit your answers to the Dropbox on a single sheet of paper. APA format is not required. No later than the last day of this LP3 when your assignments are due. That's when this is due as well. And so a couple of different things. One is, what is the closest meaning of quid pro quo? So that's, you're gonna answer whether it's A, B, C, or D. You have those choices there, and you can find this answer in your book and in your materials. This is a common Latin term. Many legal actions have these Latin terms that have different parts of them apply, and so it's important to know, to really understand what you're reading. And so this is just an opportunity for you to research and really understand the meaning of quid pro quo. It's in your book and materials. And then question number 2. This is a true or false with a brief answer, no more than 200 words. True or false? Affirmative action is illegal discrimination. So once again, that's true or false. Affirmative action is illegal discrimination. And then briefly explain your answer, no more than 200 words. My intent here is not that this take a long time, but just to really impress upon you the idea it's important to know what you're reading. It's important to know the words and the meaning of words that apply to these legal actions. And I just want to make sure on this question number 2, true or false, affirmative action is illegal discrimination. You're just going to say true or false, and you're going to briefly explain your answer, uploading that to the LP3 Dropbox in the seminar assessment. As always, if you have any questions, please let me know. Please contact me. I've heard from several of you, and I hope that my comments have been helpful to you. I just am here to support you in your understanding and gaining even a deeper understanding about what we think we know about HR law.